Welcome to SCOTUScast, a project of the Federalist Society for Law and Public Policy Studies. Our contributors join us from around the country to bring you expert commentary on U.S. Supreme Court cases as they are argued and decisions are issued. The Federalist Society takes no position on particular legal or public policy issues. All expressions of opinion are those of the speaker.
Thank you for tuning in to the October 21 term of SCOTUScast. I'm your host, Nick Garfinkel, on behalf of the Faculty Division of the Federalist Society. On May 23rd, the court decided Morgan v. Sundance, an arbitration case for which Justice Kagan authored the opinion. Joining today to discuss this 9-0 decision is Stephen J. Ware, the Frank Edwards Tyler Distinguished Professor of Law at the University of Kansas Law School.
First thing we notice here is that the opinion's unanimous. Unlike some arbitration cases that divide the Supreme Court along the predictable ideological lines, and those cases tend to be about enforcing adhesive arbitration agreements in contexts like consumer, employment, and so forth. While that may be a hot-button ideological issue, here in Morgan v. Sundance, we have an arbitration issue waiver of the right to arbitrate that has not divided the court. It's a unanimous court. And written by Justice Kagan, this opinion, similar to the most recent arbitration opinion from the court earlier this spring, Badgerow v. Walters, also written by Justice Kagan, with only one dissenter, Justice Breyer, who normally with Justice Kagan on ideologically divisive issues. So again, we have now two arbitration cases this spring that don't divide the court ideologically or really barely at all. So let's turn now to waiver of the right to arbitrate in this latest case, Morgan. So contract rights, like other rights, can be waived, and that includes the right to arbitrate. So sometimes what happens is a party seeking to enforce an arbitration agreement has participated in litigation before asking the court to enforce the agreement to arbitrate. And the other party will argue that that participation in litigation waives the right to compel arbitration. That's the usual sort of fact pattern. And prior to this Morgan v. Sundance case, many courts deciding whether waiver of the right to arbitrate had occurred looked to whether the opposing party would be prejudiced by a subsequent order requiring it to submit to arbitration. In other words, this prejudice inquiry, very fact-specific inquiry, looking at the costs a party had incurred in litigating and whether the party now seeking arbitration had benefited from features of litigation, such as extensive discovery, that may not have been available to it in arbitration. So many courts stated that requiring prejudice to show waiver of the right to arbitrate was supported by the strong federal policy favoring arbitration based in the Federal Arbitration Act, which generally enforces arbitration agreements. So strong pro-arbitration policy, many courts had discerned means we don't want to make it too quick that we find waiver of the right to arbitrate only if the other party would be prejudiced. However, in this recent Morgan v. Sundance case, the Supreme Court says no, prejudice is not required to show waiver of the right to arbitrate. Prejudice is not required to show waiver of other rights, and the Supreme Court tells us the FAA, Federal Arbitration Act's policy favoring arbitration, does not authorize federal courts to invent special arbitration preferring procedural rules. So we can see this case in the big picture of arbitration law as, does the Federal Arbitration Act favor arbitration, or does it merely require courts to treat arbitration agreements as courts treat other agreements? No finger on the scale, if you will, in either direction. So the facts of this Morgan v. Sundance case were that there was an employment arbitration agreement, and despite this agreement, the employee sued her employer in federal court, bringing a nationwide collective action alleging violations of the Fair Labor Standards Act. The employer took several steps in litigation before moving to compel arbitration. First, the employer moved to dismiss this suit as duplicative of a collective action previously brought by other employees. In this motion to dismiss, the employer suggested the employee either join that earlier suit or refile her claim on an individual rather than collective or class basis. The employer's motion to dismiss was denied by the district court, so the employer then answered the complaint, asserting 14 affirmative defenses, but none mentioning the arbitration agreement. And soon afterward, the employer met in a joint mediation session with the named plaintiffs in both collective actions, this Morgan case and the earlier filed one. And the earlier filed one settled as a result of mediation, but this Morgan case did not. Only after all of that participation in litigation by the employer, moving to dismiss, answering the complaint without mentioning arbitration, and trying to settle the dispute in mediation, only after all that did the employer move to compel arbitration. The district court denied the employer's motion to compel arbitration, and the Eighth Circuit reversed, applying its rule that a party waives its right to arbitrate if three things. If, number one, it knew of the right, number two, it acted inconsistently with that right, and crucially for this case, number three, if it prejudiced the other party by inconsistent actions. In requiring a showing of prejudice to prove waiver of the right to arbitrate, the Eighth Circuit was joined by the majority of other circuit courts. Nevertheless, the Supreme Court's unanimous opinion in Morgan sided with the minority of circuits in saying that the Eighth Circuit was wrong to condition a waiver of the right to arbitrate on a showing of prejudice. Morgan said, outside the arbitration context, a federal court assessing waiver does not generally ask about prejudice. The Supreme Court says waiver focuses on the actions of the person who held the right, not the effects of those actions on the opposing party. Morgan, the Supreme Court opinion, said this general approach to waiver applies to contracts and thus also to arbitration agreements because the FAA's policy, the Federal Arbitration Act's policy, is about treating arbitration contracts like all others, not about fostering arbitration. So that's the crux of the big picture policy point on arbitration law. FAA read by the Supreme Court as treat arbitration agreements like other contracts, not a finger on the scale to favor arbitration with rules on waiver, for example, that would make arbitration less likely to be waived than other rights. So where does Morgan leave waiver of arbitration? Morgan can be expected to increase the frequency with which parties are held to have waived the right to arbitrate, but Morgan may not end the fact-specific, sometimes inconsistent waiver rulings of lower courts. Courts have held that parties waive the right to arbitrate by filing pleadings in litigation, by engaging in discovery in litigation, or by removing to federal court In contrast, other courts have declined to find waiver on very similar litigation conduct. So there's going to be some inconsistency when you look at the case law. It's going to be fact-specific, and I don't know that Morgan will resolve that as much as take away the argument that the Eighth Circuit was persuaded by, which is the Federal Arbitration Act requiring prejudice to show waiver of the right to arbitrate. Another issue Morgan leaves open is the enforceability of anti-waiver agreements. Courts have declined to enforce a contract clause providing that participation in litigation shall not be deemed a waiver of a party's right to demand arbitration. On the other hand, courts have enforced agreements providing that bringing a debt collection claim in court does not waive the right to compel arbitration of a counterclaim by the debtor. So we have somewhat inconsistent case law out there on whether to enforce anti-waiver clauses in contracts. And then finally, Morgan leaves open the extent to which courts will characterize waiver of arbitration as a matter of state law. For instance, the Ninth Circuit has held that a federal district court erred in applying federal law to the question of waiver, and Maryland's Court of Appeals held that because waiver is a generally applicable contract defense, state law on waiver is incorporated into the Federal Arbitration Act, Section 2, and Maryland Court of Appeals on solid ground in citing Supreme Court cases, Doctors Associates v. Casaroto and Perry v. Thomas for that proposition that contract defenses are state law, and the Federal Arbitration Act brings that state law into arbitration cases using the defenses just as they would be found for other contracts. So Maryland Court of Appeals says we analyze whether the arbitration clause was waived under state, not federal law.
Thank you for listening to this episode of SCOTUScast. SCOTUScast is a project of the Federalist Society, a not-for-profit educational organization of conservative and libertarian law students, law professors, and lawyers, founded upon the principles that the state exists to preserve freedom, that the separation of governmental powers is central to our Constitution, and that it is emphatically the province and duty of the judiciary to say what the law is, not what it should be. Don't forget to subscribe to our podcast series, including SCOTUScast and Practice Group podcasts, on iTunes or Google Play. For an archive of past podcasts, as well as audio and video of past Federalist Society events, please visit our website at fedsoc.org/multimedia. That's fedsoc.org/multimedia.
This has been a FedSoc audio production.